Thank you everyone for joining us today and happy first day of spring.
Oh, I hadn't even thought of that.
Yes. And welcome and thank you for joining us for All Things Estate Planning. I am Heidi Habegger, the Executive Director here at Groundswell Conservancy. And while I am the new Executive Director, I am not new to Groundswell. I'll have been here 15 years next month. And I am happy to be joined today by our new Director of Major and Planned Gifts, Amy Mertz, who replaces me in my former role, for people who maybe have known me for many years already. This presentation today is possible because of Anna Main, sitting here next to me, an attorney with Haskins, Short, and Brindley. And we're very grateful to have her here presenting to us today about all things estate planning. Let's see, a couple of housekeeping reminders. One is that we are recording this today and we will be sharing the recording with you along with the slides so that you can share that with friends and family as well. Also, if you are remote and have any questions, please put those into the chat. We'll be keeping an eye on that and then can have Anna help answer those as we go through the presentation. And with that, I'm going to turn it over to Anna.
Okay. My name is Anna Main. I'm an attorney and partner at Haskins, Short, and Brindley. I practice in the area primarily of estate planning, but we also do some probate work, trust administration, guardianships, then also long-term care planning and Medicaid applications at our firm as well. If there are any questions that go along, please put them in the chat. I'm happy to answer them. Otherwise, we'll get started on the presentation. For this presentation today, I hope to cover a number of different areas. First, why and when to get started with estate planning. Next, I'll kind of review some fundamental estate planning concepts and also the basics of probate. And then how and why to include charitable giving as part of your estate plan. How to begin estate planning and what to expect as part of that process. And also, if you want to work with an estate planning attorney, how that process will look, as well as, you know, if you're working with our firm or kind of any other firm in the area as well. Again, we practice in Wisconsin. Estate planning is different state to state. So I will be just talking about kind of Wisconsin estate planning today. And then as for what is estate planning and who is it for? Estate planning is for everyone. So whether you have just the very simple estate in your mind or a very complex estate and family situation, estate planning is for everyone. We typically want an estate plan because it provides a legal safety net. Sure. It's easier. I can take over the mouse. You have to keep track of two things. So we're looking at 2 points during a lifetime, disability and at death. It's designed to minimize reliance on default state rules primarily. So there are some default state rules if someone doesn't have a will or if someone doesn't have powers of attorney. But it's always better to have those documents in place so you don't have to rely upon those state laws. And the size of the estate really matters in the majority of factors for why you need a plan. You're usually just trying to make it sure that the people you want to receive certain assets receive those assets as part of your will, as well as during your lifetime, you want to make sure the decision makers in the event of your incapacity are the people you would like to be the decision makers and that they understand what you would want in those situations. Basically, an estate plan is determining who, what, when, where, why, and how. And now is always the best time to really start planning.
Yeah.
I should let
You
you
do
know.
it. Screen. So what do I mean by an estate plan? So there are a number of different documents that incorporates. One of them is a will. That's probably the most commonly known. Oftentimes people have pour-over wills when they have a trust. There are different types of trusts. Today we'll really just be talking about a revocable living trust. But there's testamentary trusts as part of wills. There's also irrevocable trusts, which are typically used for Medicaid type planning, as well as a couple of other different types of planning. Those are documents that dictate where assets typically go following someone's death. Then there's financial powers of attorney, healthcare powers of attorney. We'll get into those a little bit later as well. Those are documents that are only in effect during someone's lifetime. Other ones people may have are authorizations for final disposition. That's not one I'll really touch on too much today, but that's a document that dictates who would be in charge of your funeral, as well as discussing kind of what you would want for your funeral. Kind of fits in between those powers of attorney during your lifetime, and then wills and trusts, which take a little while to come into effect after someone's passing. There's also a living will, often done in parallel with the healthcare power of attorney that discusses specific situations. And finally, a marital property agreement. Those can be done as kind of a prenup or done prior to a marriage. The one we'll talk about today is done in terms of estate planning. So it doesn't discuss what would happen in the event of a divorce. But those are kind of the main documents you see as part of an estate plan. So why would someone need a will? And as part of that, we talk about some basic concepts, and that is, what is probate? Probate is a legal court process typically used to transfer assets from one person, the decedent, to their heirs and beneficiaries. And if a deceased person has completed a will, it's usually used as part of that probate process. Typically, you're not going to end up in probate if you have beneficiary designations on everything, and those beneficiary designations tell us where your property is going to go, and we'll talk about that a little bit later. But oftentimes, a will is incorporated as part of that probate process, though not required. And if the deceased person did have a will, again, that will is dictating where it goes and is going to overcome who Wisconsin law would say should be the heirs in that estate. So the probate process is started by filing the will with the probate court in the county of where that person passed. The court then appoints a personal representative, typically the person that the will has nominated, though not always. And then the court sets a creditor deadline that tells the personal representative to file notice in a specific newspaper. And that is the newspaper in the county. So you probably are familiar with those notices. Creditors then have until that deadline, usually about 4 months down the road, to file any creditor claims. Once that timeline has passed, the personal representative is responsible for filing an inventory. And that's due approximately 6 months after that probate court case has opened. That is telling the probate court what assets are part of this person's estate that the court is going to handle. Then the personal representative is going to pay all the bills, provide an accounting to all the beneficiaries in the court, and then make distributions. Generally, I would say probate takes about a year to complete from start to finish, though in many cases, you may be required to request an extension if things can't be completed in time, or properties can't be sold, or taxes need to be paid. Especially when someone has a business, it takes a little bit longer to wrap up. Many individuals want to avoid this probate process for various reasons. There are costs associated with probate, filing in a newspaper. There's going to be an inventory fee, which is 0.2% of someone's estate. If the personal representative is from out of state, a bond may be required to be paid. And, there's other expenses like attorney's fees if you choose to hire an attorney, that will pop up as well. Additionally, probate can be more time consuming because of all the paperwork, the court, or if you have to locate unknown heirs. So just because you name certain people in your will to receive your property, you still have to notify all of the heirs at law, which can be quite cumbersome. At times, there may be 100 relatives that fall into the family tree, and we'll get into that a little bit later. So for those reasons, a lot of people do choose to want to avoid probate.
Can I ask a question?
Absolutely.
So if you don't designate who you want to be your personal representative to handle the estate, then does the probate court decide someone to take that, an attorney or whatever, to take that role?
So if probate is required, someone is responsible for filing that application. So that could be, if you own a home and have a mortgage on it, it could be the bank, or it could be a friend or a relative. In that document, they nominate someone. So
In the will? Or,
in the application, so if you
Okay.
don't have a will, or
I
if you
see.
haven't nominated someone in your will, the court will, require as part of the application that someone is nominated to serve. So that could be a corporation, could be a bank, it could be just an attorney in the county who got the phone call from the court. So it ultimately is appointed by the court, but for that reason, we do typically recommend you choose someone to serve. If you have a corporation or an attorney serve, it could be quite costly on your estate. Another concept that does come up as part of the probate process is what is marital property. So it's a property classification system that applies by default if you're a resident of the state of Wisconsin. There are also a couple other states to see. Wisconsin's kind of an island of marital property, and then they're primarily on that southwest coastline, the other states that have marital property. It can be modified by an agreement. Otherwise, there is the presumption of marital property. Typically, it's compensation earnings on individual property, as well as commingled property that is difficult to trace. In Wisconsin, if you're married, everything is presumed to be marital property and equal regardless of whose spouse's name it's titled in. Individual property can be proven through tracing if it was property that was inherited or gifted during the marriage, as well as any property that was brought in. However, because of that mingling rule, oftentimes property that's brought into the marriage does become marital property. It's an important concept if someone has strong feelings about certain pieces of property being individual and under their control, about who they distribute it to as part of their estate. Just because someone didn't do a marital property agreement prior to marriage doesn't mean that we can't dictate that property is individual property after the marriage or during the process. And that's where the marital property agreements can come into play. So what exactly is a will? It allows for the transfer of property at death when there's no beneficiary designation or transfer on death designation, payable on death designation. That's what those TOD, PODs are. It allows for the distribution of tangible personal property as well. So things that don't have title or paperwork that you can really dictate. It also allows for the naming of a guardian for minor children or children who have incapacities and may need a guardian while they're an adult. And finally, it allows for the naming of the personal representative or executor. It's going to control really that personal property, real estate for individuals. Personal property, I think, is probably one of the most common things that passes through wills. Wisconsin does require that it be in writing and signed in the presence of 2 witnesses. If you're doing or working with an attorney, we do typically notarize that document as well, to kind of really resolve any question of whether that's an authentic document. So do you need a will? So this typically requires a review of the property that you own. Whether you have property subject to probate process. So property that is subject to probate, is typically property that can't have title. So again, that personal property. Or can only be titled in their individual name. Property not typically subject to probate are your retirement accounts that you can place beneficiaries on, life insurance, payable on death accounts, typically bank accounts, transfer on death accounts. Think your brokerage, your stock accounts, and then property that's titled jointly. So real estate often is owned as survivorship marital property, some of the most commonly jointly titled property I think that's out there. I believe there was a question about transfer on death deeds. So that is an allowable document in Wisconsin where you can essentially place a beneficiary on your real estate. So a lot of our clients who want to keep their estate very simple, but have a, primary residence, we do a transfer on death deed to their adult children. So upon their death, or if they're married, the second spouse to die, that property transfers automatically to their children. It doesn't have any major tax consequences. They still get what's called a step up in basis at the second spouse's death, which avoids capital gain tax to some degree. I'm putting an asterisk on that. I'm not an accountant. Always talk to your CPA if you have tax questions, but it is another way to transfer that property and avoid probate. For that specific residence. It is revoked upon the sale of the real estate and only is related to that piece of real estate. So if someone sells property and purchases a new one, it does need to be redone every time. Another way to transfer property is a marital property agreement. I'll just touch on this because I don't think this is as common as it used to be. But typically this is done as a postnup where you're dictating where you want your property to go as part of that agreement. It does hold up as kind of an estate planning document, but it's also one that's a little bit more complicated to amend and change as time goes on. So it's not typically the standard recommended way to do estate planning, but it was done quite commonly, I think, previously. So we do see it, and it does work to transfer property. Not all banks recognize marital property agreements as a document that can transfer property, especially banks that are federal and don't work in Wisconsin primarily. So we do see some difficulty with that being accepted everywhere. So do you need a will? The benefits of a will are the ability to consider a beneficiary's individual characteristics, circumstances, or special needs. So especially if someone has minor children or a child who has special needs and is an adult, it's a great way to dictate how you want that property held if you don't want them to receive it outright. It also allows for disposition to friends, charities. It allows you to appoint that personal representative or guardian, especially if you don't have a close family member, friend, spouse who would step in. It allows you to appoint someone like a corporate guardian or a corporate trustee or personal representative, and allows you to talk to them before they would step into that role. So you understand what the fees associated with that are. You've built a relationship with them so they understand what you want carried out. And it allows you to build your own succession plan for management of your estate and distribution of your property. One of the common questions we receive is, if I don't have a close family member or friend, who can act? We do have banks locally that will step into that role of personal representative or trustee. Obviously, they do charge fees, so I always recommend having that conversation with them. Not all banks do. A lot of credit unions will not act in this role. And then there's also corporations that just do this. One of the biggest ones in our area is fiduciary partners. Again, it's always best to have a conversation with them so you understand what they will do, what they won't do, what they will manage, and what the costs associated with that are. And then keep in touch with them because fees are always subject to change. So other questions people have with regard to wills are how to handle unique family situations like second marriages, And if you have children from the first marriages, like if both spouses do, how should our assets transfer? Family members with unique needs. Our office works a lot with families who have children with special needs, helps them set up trusts specifically to manage this. There are some nonprofits that we work with who will manage those trusts and make appropriate distributions. Especially with families who just have one child with special needs and the other children don't want to serve, or maybe it's just a single child and they don't have another family member willing to step into that role. It's a great thing to plan for. Also, if you wish to give to charity, a good discussion with an attorney or with the charity itself on what assets they will accept, what's the best way to transfer property to them, what's the best way to leave property, how much you want to leave. If you want to leave any non-standard distributions like bequests, or if you have minor children or concerns with your children's money management skills, how to incorporate that within a will. None of these are really part of the default rules in Wisconsin, so always best to have a will in those circumstances. So kind of on the related but kind of different is a revocable living trust. So it's actually a document you're creating during your lifetime. You are still going to have a will in most circumstances, and it's going to be called a pourable will. And that just catches anything like that tangible personal property, nominating of guardians, which is required to be part of the will. But the goal of a revocable trust is often to avoid that probate process. Again, you're creating it during your lifetime. It can always be, if it's revocable, amended, modified to incorporate changes throughout your lifetime. But it does also provide for management of assets during lifetime, as well as after death. And specifically, it is dictating where you want your assets to go following your death. Typically, you're going to do a joint revocable living trust if you're a married couple. But again, there are different types of trusts we're not going to be talking about today, like irrevocable trusts for Medicaid protection. That's the long-term care program through the state of Wisconsin that provides care for residents in nursing homes or assisted livings. And the primary goal of an irrevocable trust is to protect your assets from estate recovery as part of that process. So why would you want a revocable trust rather than just having a will? There are a couple different reasons. The primary one I think we see is privacy. So the probate process is completely public. So the public is going to be able to access that inventory that's filed, the accounting, where did your money go, how much money did you have, those type of things. And not everyone wants that to be public. So a trust allows for you to keep those details private. It also allows for usually reductions in conflicts between family members. If you anticipate someone to object, it does prevent certain family members from having that authority.
Question?
Yes.
So how do other people find out what's in your will? Because it's in the newspaper or something,
So
what is the threat of loss of privacy? How great is that?
sure. So the probate process, there is a requirement that it be published 3 weeks in a row that you have filed to open probate. The will itself is not public. It's just usually the name and the courthouse where the case is filed. So then people can CCAP it. In Wisconsin, you have that electronic access to see what has been filed. But to actually get a copy of the will, you typically have to go down to the courthouse and request one, or you can, I believe, not request one online, but it's not a public document per se. They would have to do some work to get the document itself.
And is the notice in a print newspaper or an online?
Both.
Both, okay.
So it's usually one that does both. So it's printed and then all of those notices are available electronically as well. So historically, trusts have been used for tax planning purposes. That's not as common these days because of the tax rules that have changed over time. So right now, in Wisconsin does not have an estate tax, and the federal estate tax has an exemption where you have to have $13.99 million before you're going to be responsible for paying any estate tax. I'm not referring to income tax or capital gains related to your estate. Just simply the estate tax, which is 40%. And if you're married, that does double. So you each have that 13.99 million exemption to use during your lifetime or at your death. However, trusts do again bypass that probate process. It allows you to maintain property characteristics throughout your life. So the same real estate you own during your lifetime, your trust is going to own following your death. So if you want to have your family hold that in trust or want it to be managed in some sort of way following your death, you can allow for that. And if something happens during your lifetime where you have an incapacity, the same person, you can nominate the same person to be in charge of your trust during your lifetime as you would following your death. The trust doesn't change anything tax-wise typically. It's kind of acts as your alter ego. Your tax ID number, so your social security number, is the trust tax ID number. So it doesn't require, it should not require any additional tax forms during your lifetime, so long as you are serving as trustee. And then again, it's dictating where your property goes, and if you want to utilize a corporate trustee, you can name that corporate trustee specifically. There are some disadvantages of a trust. They can be a little bit cumbersome to set up. You have to do typically some paperwork, whether it be transfer of real estate or setting up your bank accounts if you choose to do so during your lifetime as trust accounts. It's not necessarily set it and forget it. It may require some updates during your lifetime if you want to modify how your property is distributed. But if you set up the trust as a beneficiary on an account, and you want to change who your beneficiaries are, you don't have to go back and change your beneficiary designations for each of your retirement accounts, for example. So it is a little bit easier that way. It can be potentially costly to administer, especially if you do choose to use a corporate trustee, because they do charge fees, especially if you want to maintain the trust for a certain period of time following your life, or following your death, I should say. So if you pass away, your children are 25, you want their money to be held in trust until they're 35, and you want to use a corporate trustee, that corporate trustee is going to charge ongoing fees.
I have a question about another disadvantage. Should I bring it up now or later?
Absolutely. You can bring it up now.
Okay, so we talked with our credit union about what would happen if we set up a trust, and it would require creating new accounts, moving our money to our new accounts and closing our the other ones, which that's another disadvantage.
Yes, so typically our office doesn't recommend that you actually close your accounts and open up trust accounts during your lifetime, just that you make your current accounts payable on death to the trust. So essentially name the trust as a beneficiary. So the trust is going to get a new tax ID number once both of you have passed. So typically your successor trustee following the second death is going to be responsible for setting up new bank accounts at that time anyway. So at that point, they would close out the accounts and open up new trust accounts.
Okay.
They as trustee would have the authority to be that designation, that payable on death designation. So that's one way to avoid some of the extra paperwork, some of the moving the accounts, your payments, all of that around. So what happens if someone doesn't have a will or a trust? So as we kind of discussed previously, Wisconsin laws of succession step in. Property passes to surviving heirs. So typically this is going to be your spouse. If not your spouse, then your children. If you don't have a spouse or child, then your parents. If your parents have predeceased you, your siblings. And then if one of your siblings have predeceased you, then their share goes to their siblings. So it's called first terpies. Think of it like a family tree. Equal distributions based on family line. This excludes any charities, any special needs planning you would do. And if you fail to appoint a personal representative or guardian of a minor child, it's, as we kind of discussed, typically the loudest person in the room or the one willing to actually serve that steps in. Finding those default beneficiaries can be a bit expensive. Typically, it requires an heir search. So you hire a company to essentially put together that family tree. The most we've had is probably 20. I know other firms have had like over 100 heirs. It can get quite expensive to find them all. They all get notice. It's just, it can be a complicated process if you haven't dictated who you would like.
So about how far out does it go? Because I know it goes to like siblings and then siblings' children, but how much farther than that does it go
It
if you don't have a spouse and children?
It really, if you don't have a spouse or child, and presumably your parents have predeceased you, it goes to your siblings, but it's the line stops where the last living sibling is. So if you have at least one living sibling, you still go to all of the deceased siblings and then their children. And if they don't have, if one of their children have died, then you have to find their grandchildren. So it really depends on the size of the family. If you have a large Catholic family, it can get quite extensive. It really depends.
Okay.
So kind of moving on from post-death, looking at the documents you would use during your lifetime. The first one we'll touch on is the durable power of attorney for finances and property. You as principal are naming someone to act as your agent or attorney in fact. This document allows you to appoint an individual or again a corporation to handle your finances, again, only during your lifetime. This power does end at death. It can be effective immediately, but I think a lot of people, especially if they don't have a spouse, are more comfortable with it being what we call springing. So effective on a specific event, typically your incapacity. And you can control the authority, make it broad or as limited as you want. Responsibilities can include tasks like opening and closing bank accounts, paying bills, selling cars, real estate, applying for public benefits, managing any other financial duty, including accessing like online accounts. You can have your power of attorney have pretty broad authority. Some of the more limited ones that you can have are gifting as well, whether it be gifting to spouses, children, charities. That does have to be specifically outlined within the document. So if you have left out any reference to gifting, your financial power of attorney would not have any authority to continue any ongoing gifting plans that you have put in place. Again, you have that immediate power of attorney, authority. Again, we typically do this for spouses most commonly, or someone who has concerns about their incapacity fairly soon down the line. You want to make sure that anyone you're naming, you feel comfortable with. So if you don't trust this person, probably not the best person to name as your financial power of attorney. You can still have a financial power of attorney and still manage your own affairs. You haven't given any of your own authority away with this document. It doesn't take any authority away. So I think one of the most common things we see is a child bringing a parent in and saying, this person has been fallen prey to scams. The financial power of attorney doesn't take any of their authority away. They can still go and write checks out of their bank account, all of that. The only way to take power away would be through a guardianship process or a conservatorship. So it doesn't give any authority away. It just allows someone to help you. Springing power of attorney, again, similar to what we'll talk about with the healthcare. The most common way to draft this would be effective upon 2 doctors or a doctor and another healthcare provider's signature stating that you lack the capacity to make your own financial decisions.
Could this be like after a stroke or like after, you're kind of be like going to coma? Could it be that you have to
Yes.
lay out or?
I'd say the most common reasons why doctors determine someone lacks capacity is their inability to communicate. That's typically a coma, stroke, some sort of medical event. Just because you've activated these type of documents, you can still deactivate them. Even a healthcare power of attorney can be deactivated, so it doesn't mean it's going to be permanently in place. The other common thing we see is someone has dementia or Alzheimer's. So at some point they reach the stage where they can't manage their own finances and a doctor has to turn their back. The comment on that note, the power of attorney for healthcare, it's a written authorization given to you or given by you as principal to another agent to act on your behalf and make healthcare decisions. Typically, in this document, we're only naming one agent at a time. Financial power of attorneys, you can name co-agents to act together jointly or separately. In this situation, we only want to name one at a time. You never want to have two people disagree on a healthcare decision because then you basically don't have an actor. It's only effective when activated by a physician or a physician or another healthcare provider. And it's typically done in conjunction with HIPAA releases. So you want to have a HIPAA release when you have a healthcare power of attorney, because you want them to be able to speak to the doctors and access your medical records. Wisconsin is not a next of kin state. So if you do not have a healthcare power of attorney and you have an event where you can't make your own healthcare decisions, typically the next step is guardianship. There's no one who can step in by law and make those decisions for you. Not to say a doctor is not going to look to a family member in a medical emergency, but it's always best to have something in place.
So would you say then at any point, it would be smart to have a power of attorney for healthcare?
Absolutely, yes. So we recommend them once you've turned 18, you can do one. So if someone goes away to college, we always recommend it. Because the parent cannot make the medical decisions once a child has turned 18. So everyone 18 and up should have one of these in place. We do typically recommend that once you've signed it, you bring it into your doctor. They will scan it into your medical healthcare records. So someone is not trying to look for it in a medical emergency. Other states are supposed to recognize a power of attorney from another state. So in Wisconsin, the doctor is supposed to recognize an Illinois or Minnesota power of attorney. So we do have a lot of snowbirds in Wisconsin. So Arizona, Florida, wherever you spend the most time is probably the place where you should have that document from that state. Because while doctors are supposed to recognize documents from other states, they don't always understand those documents because they don't look the same from state to state. Ours looks very different from the Minnesota healthcare power of attorney. So wherever you spend the most time is probably where you should have that document from. Or if you move, you should redo it in whatever state's healthcare power of attorney or of the state you move to.
A common thing, I'm a retired nurse, that we got almost daily at the hospital was family would come in when their loved one was in the hospital. I'm the healthcare power of attorney. It's like, that's good to know. Give us a copy of the document. You don't get to make any decisions until the physicians decide that they're incapacitated. They think they, like the financial, they can make decisions now.
Yeah.
But it's like, nope, not until that happens. You
Not
don't
until
get to have any say. But
not
they always
until it's
think,
activated.
I'm not, it's like, yeah, good to know, but not until that happens.
So who can make decisions in that situation if there's no healthcare power of attorney? Guardianship takes a long time, right?
It does take time. Technically, no one. The doctor has to make the best decision they can.
So the doctor makes the decision.
Technically, they can't get moved into any other facility outside of the hospital. They just have to kind of keep them alive. They don't have any authority to do anything else. Again, not to say that the doctors don't look to the next of kin for very emergency decisions or have those discussions with family
Okay.
members, but technically they're not supposed to. I'm giving you the legal advice, not what is
Yeah.
practical day to
Somebody
day.
has to, right.
So again, that power of attorney healthcare standard is not modifiable. Like when it is activated is by state law, determined by state law. So we can't modify that within the document.
So even though it's not really activated until that person is considered to be incapacitated, I still am able to use it to talk to doctors about my brother, to help make decisions. It's not like an either or thing.
So that's kind of where a lot of doctors view it as a HIPAA release.
Mhm.
So they allow those conversations. But the ultimate decision maker, and you can't overcome your brother's decisions. Not to say you can't help him with his decisions, but you can't override his decision, even if he's making a bad decision, until it has been activated. Or a doctor should not allow you to. Again, I can't say what a doctor does or does not do, but that's kind of by law that you can't override someone's decision until the health attorney is there. So someone had asked a sibling versus adult child, who's the best to make those decisions? Really, the question comes down to who would you want to make your decision and who do you think would make the decision you would want in the event of a healthcare emergency. So if a child is 18, are they going to have the capability to understand, comprehend, and make that decision just because they're an adult? Or would a sibling be a better, more appropriate decision maker in the event of an emergency? Who's going to be available? We can do a lot with today's technology. Doctors can call someone who's in a different country or Zoom them in. They can still make the decision. So it's not necessarily who's the closest person. It's really who you think is the most appropriate, most responsible, who's going to pick up the phone and not call back a week later. So think about a number of factors there. And then whoever you choose, make sure they know what you would want in a certain situations. One of the biggest things we have is adult children come in and say, my parents never had the discussion. I didn't know when to pull the plug. So having those conversations before that medical emergency is always a good idea. So moving on from powers of attorney, when would you want to consider charitable giving as part of your estate plan? There are a lot of benefits of charitable giving, non-financially. People want to pay it forward. There's obviously an emotional benefit to charitable giving. It creates a culture of collaboration and community involvement, especially during your lifetime, giving of time, giving of money. And oftentimes, those charitable giving reasons are, they're needed by the recipient, possibly more than a relative. The benefits of charitable giving financially is typically tax planning. So that's during your lifetime, giving to charity can earn you an income tax deduction or reduce your affordable income. Giving through your estate plan can potentially provide you your estate with an estate tax charitable deduction. So if you think your estate is going to have income tax for any reason, there is a charitable deduction piece as part of that estate tax. In terms of, again, is federal estate tax, the 40% tax, we just don't see many people are going to hit that. So it's really a conversation. What's the best way to give your assets and have that conversation with a CPA or an estate planning attorney? Because there's typically certain reasons to give certain assets to charity versus to your child if you're splitting up your estate in that way. One of the best things I guess not the best things, but one of the things we advise people to do is take a look at your assets. What's going to potentially have a tax that a charity can potentially avoid versus a child? So appreciated stock and real estate are two of the most common assets. However, especially when we're talking about real estate, not every charity is an appropriate beneficiary of real estate. Not all charities can receive real estate. So we always recommend reaching out to those charities, having those conversations. Would they accept real estate, or are they just going to have to disclaim it because they don't have the capabilities to manage it and deal with that real estate? So if your goal is to give something generously, you want to make sure you have the conversation with that charity and make sure they are able to receive it. Another thing is qualified charitable distribution. Donors who are 78.5 years or older can donate up to $108,000, I believe, total to one or more charities directly from a taxable IRA instead of taking the required minimum distributions. So a lot of people, more and more commonly, one of their biggest assets are their retirement accounts, and they do have concerns about these required minimum distributions and the effects they have on their income. So this is a great way to give as well. Again, let's talk to a tax planning professional. So via your estate plan, there's different ways to give. Again, we talked about the retirement benefits. You can give outright distributions of property, whether that be real estate or cash. You can name them as the beneficiary of your life insurance policies. And then there's always considerations about, do you want to include them as a percentage beneficiary, or do you want to leave a specific request? And these are conversations I recommend having with an attorney who can look at your total assets and the best way to distribute them with you. Wrapping up on considerations for your estate plan that we spoke of. Again, we want to coordinate the roles of who your agents are. Potentially, you want your financial power of attorney agent to be able to communicate well with your healthcare power of attorney agent. If you're incapacitated and need to move into a nursing home, someone's going to have to pay the bill. That's your financial power of attorney. Someone's going to have to make the decision on where you're placed. That's your healthcare power of attorney. You don't want those conflicting. And then, funding your trust is if you have a trust, or naming beneficiaries of your different assets. You want them to coordinate. So if you want to leave a bequest in your will to a charity, you don't have a trust, but then you name beneficiaries on all of your different assets outside of that will is never going to receive any funds. So that bequest is never going to be able to be paid. So you want to make sure these documents coordinate your actual estate planning documents and then your beneficiary designations. Do you have beneficiary designations on all of your accounts? If you want to avoid probate, that's very important. And then should you write a letter of instruction? So this is a document kind of outside your estate plan where you can better lay your wishes out for things that are not appropriate to put in your estate planning document itself. So if you have concerns about a child, you're creating a trust for them, you can kind of lay out, and you're naming a corporate trustee, you can lay out what your concerns are, what your goals of spending are, why you did this in that letter of instruction, and then update that as time goes on and don't have to update your actual estate. Not everyone does this, it's completely optional, but it is an option, I like to tell people. How frequently should you review your estate plan? So kind of the accepted standard is every 3 to 5 years. If you are keeping track of estate planning law, there are at times changes in applicable law, whether that be tax law or the actual trust code in Wisconsin changed last year. So there's things where you may want to touch base with an attorney if things changed. And then life changes. Did you inherit something? Did someone pass away that you named in all of your documents and you want to update that? Did you have a new child? Did you just get married? Those are times where you want to update your estate. And how to get started. So you want to make sure mainly that everything you're doing, your plan, reflects your current situation and goals. So as part of that, we encourage people to gather the key information. What are their assets, debts? What are their beneficiary designations? Who do they want to name? And then consider who they appoint in each role, whether they have someone to appoint or whether they want to touch base with a corporation to appoint them. What are the goals for distributions and who are your intended beneficiaries? And kind of looking at the assets and the beneficiaries, who's the most appropriate for each. And then again, just review these. What is the scope of your current plan? Are you comfortable with it? Review it every few years. And then again, we just want to account for family dynamics and as those change. So if you've named, 2 siblings as your financial power of attorney, co-agents, things may change where they may not get along anymore. Something may happen. You want to make sure you update that plan. Or someone may have an accident and then have a disability. And we may need to consider special needs planning for them because they're receiving benefits that receiving a large inheritance could make them lose their benefits. So it was want to keep in mind that as well. So what to look for and expect with the estate planning process. So you want, if you reach out to an attorney, for them to promptly respond to you. You may not have an appointment immediately, but at least you want to get a call back from that office. Having a fee discussion, you can have that as part of the initial phone call, whether it be with the attorney or receptionist, but they may not be able to clearly give you a fee until they better understand what you want, whether you want a will or a trust, and that may be a more in-depth discussion. Some attorneys charge hourly, some charge a flat fee. You're probably looking at for an estate plan in the Madison area, anywhere from $1,000 to $4,000. It really depends on if you're looking for a will or a trust, what kind of trust, that type of thing. And you always want to be able to review those drafts with the attorney. Have them answer any questions you have before you sign that document. Once you've signed it, you're typically done. It's a lot easier to make changes before you signed it. So if you have any questions, concerns, revisions, don't show up with all of those to your signing appointment. Make sure you review those with the attorney beforehand so everything can be smooth for you and for the attorney. The attorney doesn't know that you have any concerns until you tell them. And that's kind of the end of my presentation. Are there any questions through the chat or any others?
Where should I keep my will? If it's in my bank box, is that a problem?
Only if no one else besides you can access that
Yeah.
box. Because once you've passed away, a lot of banks allow you to fill out a beneficiary form essentially on that bank box, that when they show someone comes with a death certificate, then they can access that bank box. You may need to update this form. Anything with the bank, I say, just like your estate plan, check to make sure it's still in place every 3 to 5 years. Banks run on software, and that software loses things, unfortunately. So beneficiary designations, anything like that, power of attorney things, rep payee forms, make sure you check every 3 to 5 years that bank still have that on file. Otherwise, if you don't have a safety deposit box at a bank, we typically just recommend fireproof, waterproof, safe in the house. Again, with someone who knows where it is and how to access it following you.
If you, and I know you didn't really touch on the non-revocable trust, but does a non-revocable trust put obligations on your beneficiaries while you're living that might be a burden to them as far as
Like it would it require them to be named as trustee or something like that, or
just as far as like I mean, does the trust pay the taxes and property taxes and stuff, or would the beneficiaries end up having to fork over money at a time when they might not have the resources to do it?
Sure. I can only speak to the trust, we do at our office. But from my experience, most irrevocable trusts are set up so the trust is always going to be responsible for those, if you're putting real estate in it, it's responsible for the property tax, it's responsible for the insurance. Typically, you are the grantors of that trust, the ones putting the property in are still residing in that property, still responsible for all those expenses. It should look fairly similar to a revocable trust in that way. The main thing is you have actually gifted it. So you are, as grantors, giving up certain access to that real estate in terms of the equity in that property, the principal of that property. And that's what you've given up. You haven't given over any responsibility necessarily to the beneficiaries until you both have passed. So you are kind of giving up access to things like home equity lines of credits, Most banks won't give a mortgage to a property that is held in their trust.
I have a question. I don't know if you can answer this or not, but I'm a single person, do not have any dependents. So do I need life insurance? I've had life insurance, but it's just like, I know with I was talking about my mom's estate that, certain things have to be paid, like funeral expenses and things like that.
Mhm.
And so, I'm kind of thinking, well, the life insurance, I should at least have the amount of what would cover a funeral.
Mhm.
So that my family, my siblings, would not have to come out of their own accounts to pay for a funeral, because that funeral home is still gonna need to be paid. And
Yeah.
estates take time to settle. So they wouldn't have access to money from my estate to pay for the funeral. So that's kind of my thought. I don't have more than that in there, because I kind of thought, I don't need all that. I don't need $100,000, because I don't have any people that I'm responsible for that life insurance would normally cover.
So I'm an attorney, I don't sell life insurance.
Yeah,
I'm sure,
but-
so I don't have
Yeah.
complete knowledge of life insurance, but in my experience, there's a couple different ways to pay for funerals if that's your biggest concern. One is if you know you're going to stay in a certain area and you know where you want your funeral to be, you can usually prepay.
Yes.
Some people
Okay.
use their actual insurance policy if it's not like whole life,
Yeah.
to prepay for their funeral. Otherwise, depending on what you want, the cost of a funeral can also vary. So getting buried, getting cremated, I should say, looks very different than if you want a natural burial
Right.
somewhere.
Sure.
So those are all considerations, but if you don't have life insurance and if you choose not to continue to pay for life insurance or can't get it anymore, I usually recommend prepaying or setting aside a specific account and saying this, I'm designating kind of as my
Okay.
funeral bank account. We're not touching it. Telling someone else that it's there or giving someone else access to it.
Okay, so they would need to have
specifically.
access to that account.
Potentially, or you could name them as a,
Beneficiary.
designation. Mhm.
Okay.
If
Yeah,
you feel
that's
comfortable
weird,
that
it's
they
like-
can cover the cost for
Yeah,
a
so
month
like,
until
do I
they
need
can
to be
get
paying this
access.
life insurance policy? It's just me. And I was just thinking, well, funeral, that may be, that would need to be a cost. So right now I have it set up that it's just covering what the average cost of a funeral would be that I think I would want.
I'm
And
not
so
gonna
it's like,
tell you whether
No,
to
no, no.
have it or
No,
not,
but I was
but
just
if
thinking
people
if you thought-
can't, these are the
Yeah.
other options. that
Yeah,
people
okay.
have.
That's good to know. Thank you.
I'll step back over here in the camera a second just to say thank you everyone again for joining us. As you saw, hopefully on the slide, Anna Main's information at Haskins Short Brindley. We will also share that information in the follow-up email that we'll send out again with the recording. We will share her slides, her contact information. If anyone has any specific information for Groundswell Conservancy, if you're interested in including us in your will or estate plans, you can certainly reach out to myself or to our new Director of Major and Planned Gifts, Amy Mertz. And there's also some information on our website as well, but again, certainly feel free to reach out to us. Thank you again, and I hope this was helpful. I know I learned something every year we host this, and every year I learn something. So thank you very much. Again, happy spring.
And I have a question regarding an irrevocable trust in relationship to Medicare?
Medicaid.
Medicaid, yeah, I'm sorry. Assuming